Mr. Brooks talked about at times this being the will of God or that all things happen for a reason. I'm here to tell you, Mr. Brooks, you are not an instrumentality of God. Death may be inevitable to all of us, but you cut the lives of 6 individuals short. You alone, Mr. Brooks, cut the lives of these 6 innocent people short. I talked earlier about how I believe he's intelligent, deliberate, and purposeful in what he does. I've considered that you have treatment needs. Perhaps there are intersecting mental health issues as it relates to your personality disorder, but those issues can best be addressed in a confined setting where the Department of Corrections will be charged statutorily to evaluate you and to provide any medical or mental health treatment that you need. This is a case that falls squarely on the need to protect the community. I referenced this earlier. There's really 3 primary reasons for the sentences I will impose here today. One is punishment, one is to protect the community, and the other is to provide justice and closure to the victims. Because under that category of need to protect, the court does get to consider the impact of these crimes on the victims. I went through at length in reviewing all of those victim impact statements. I certainly didn't go through every single one, just highlighting some of them, but doing so with purpose, because it is very clear to this court that Mr. Brooks has caused carnage, mayhem. It has resulted in many people suffering from PTSD, from mental and emotional trauma that will take a lifetime to recover from, and for some, perhaps, if at all. You have taken away from these individuals future memories. They will never have birthdays with the 6 individuals who were killed. There will be no weddings. There will be no graduations. There will be none of the milestones that these families were looking forward to, whether it be for an innocent 8-year-old or an innocent 79-year-old. Frankly, Mr. Brooks, no one is safe from you. This community can only be safe if you are behind bars for the rest of your life. The actions of Darrell Brooks demand punishment. The community is not safe from your violent and criminal conduct unless you are in custody. You left a path of destruction, chaos, death, injury, confusion, and panic as you drove 7 or so blocks through the Christmas parade, never once stopping or seemingly caring about the wake of carnage that you left. 4 of those blocks were turned into a scene that frankly is no different than a war zone. On counts 1 through 6, this court is imposing a life sentence without the possibility or eligibility for extended supervision consecutive to one another. 1 life sentence for Virginia Sorensen. 1 life sentence for Leanna Owen. 1 life sentence for Tamara Durand. 1 life sentence for Jane Kulik. 1 life sentence for Bill Hospital, and 1 life sentence for Jackson Sparks. I've considered the enhancer and the additional 5 years that I could impose, but I don't need to really order that because I've not made him eligible for extended supervision, and it would only be to increase his time on initial confinement. But make no mistake, Mr. Brooks, you use that vehicle as a battering ram, no different than, frankly, a firearm. On counts 7 through 67, these are 61 counts of first-degree recklessly endangering safety. These charges alone and these convictions without the enhancer carry a maximum of 12.5 years. Because of the enhancer, a total of 17.5 years. And under Wisconsin law, the 5 years is added to the initial term of confinement. So what could be 7.5 years is a maximum of 12.5 years. And I'd ask that everyone no longer show any reaction to the sentence so I can get through this. On counts 7 through 67, on each count I will impose a total sentence of 17.5 years. 12.5 years of initial confinement, plus 5 years of extended supervision, consecutive to any other sentence that I've imposed here today. That is 762.5 years of initial confinement and 305 years of extended supervision on top of the life sentences that I've imposed. That is 17.5 years, sir, for Nicole White. 17.5 years for Eleanor Anders. 17.5 years for Sasha Catalan Castillo. 17.5 years for Maura Gilchrist. 17.5 years for Justin Gullickson. 17.5 years for Harry Guilfoy. 17.5 years for Aiden Lofgren. 17.5 years for Theo Mazza. 17.5 years for Tyler Pudliner. 17.5 years for Connor Tank. 17.5 years for Eric Teagues. 17.5 years for Adelia Maffioli. 17.5 years for Kelly Graybow. 17.5 years for Josh Craner. 17.5 years for Riley Rogers. 17.5 years for Caden Rogers. 17.5 years for Tucker Sparks. 17.5 years for Isabella Bartlett. 17.5 years for Yaritzi Becerra Montez. 17.5 years for Samantha Coelho. 17.5 years for Madison Hollingsworth. 17.5 years for Mackenzie Hollingsworth. 17.5 years for Mitchell Lampine. 17.5 years for Kathleen Pielmeyer. 17.5 years for Julia Schleichow. 17.5 years for Olivia Stover. 17.5 years for Jennifer Stover. 17.5 years for Jesselyn Torres. 17.5 years for Alice Urell. 17.5 years for Charlotte Urell. 17.5 years for Vivian Urell. 17.5 years for Grayson Urell. 17.5 years for Lola Hospital. 17.5 years for Tamara Rosentreter. 17.5 years for Betty Strang. 17.5 years for Maria Alvarez Dominguez. 17.5 years for Gregoria Romelia Perez. 17 and a half years for Elliot Hallmark. 17 and a half years for Benjamin Hallmark. 17 and a half years for Patrick Heppy. 17 and a half years for Lori Locken. 17 and a half years for Marisol Lopez Gutierrez. 17 and a half years for Adair Lopez Rubilar. 17 and a half years for Juan Marquez. 17 and a half years for David Marquez. 17 and a half years for William Mitchell. 17 and a half years for Jason Petchloff. 17 and a half years for Margaret Pachulis. 17 and a half years for Yamilet Perales Alvarez. 17 and a half years for Aylan Perales Alvarez. 17 and a half years for Ashley Perales Alvarez. 17 and a half years for Jose Perales Alvarez. 17 and a half years for Maria Perez. 17 and a half years for Camila Perez Gonzalez. 17 and a half years for Isaac Foglia. 17 and a half years for Deborah Ramirez. 17 and a half years for Charles Green. 17 and a half years for Lily Green. 17 and a half years for Brinley Harris. 17 and a half years for Kelsey Knapp. 17 and a half years for Owen Briciotti. On counts 68 through 73, which are the 6 counts of hit and run resulting in death, these are 25-year felonies each. The court will do the following. On count 68, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision. This will be concurrent to count 1. Count 69, the same sentence, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 2. Did I say that the right way, the first one? Okay. Count 68 is concurrent to count 1. Count 69 is concurrent to count 2. Count 70, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 3. Count 71, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 4. Count 72, 25-year total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 5. And on count 73, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 6. On count 74 and 75, the 2 felony counts of bail jumping, the court is ordering a 6-year sentence total on each count, 3 years of initial confinement, 3 years of extended supervision, consecutive to all other counts but concurrent with one another. And lastly, but certainly not least, the maximum sentence for the battery to Erica Patterson, 9 months consecutive to any other sentence. To order anything other than what I have done, sir, would be to unduly depreciate the seriousness of these offenses. It is needed, although largely symbolic, given the number of years that I have imposed here today, because frankly, you deserve it. I know it's symbolic, but it needs to hold you accountable in a very real and tangible way. For all of these sentences that I have imposed, I will order the following conditions: no contact with the victims as identified in the amended victim key or their families, no contact of any kind with Erica Patterson. You are to pay restitution in the amount of $47,193.29 to EMC Insurance Company, that's on behalf of the Waukesha School District, and $124,220.65 to the Crime Victim Compensation Program. I am ordering DNA surcharges on all counts. On counts 1 through 75, it's $250. On count 76, it's $200. Those are mandatory under the law. I'm also imposing the domestic abuse surcharge on count 76 of $100. I'm also imposing all standard court costs on all counts. Although my primary emphasis is that restitution be paid before costs, surcharges, and fees, I will order that restitution, costs, and fees be paid out of prison money. In other words, that all financial obligations shall be collected pursuant to statutory provisions as requested by the state. That's frankly a standard, it's customary, but it will be in the judgment of conviction. And then pursuant to 949.165, I'll find that it is appropriate for this court to order an escrow account under 949.165 for payment of restitution, costs, fees, surcharges, and even for costs associated with prior legal representation or future representation under the statute. Mr. Brooks has been convicted of a number of serious crimes for which this section is appropriate. I will order 360 days credit as to count 1 and count 68. Only, all other counts, 0 days credit because of the consecutive nature of the sentences that I've imposed here today. I calculated that with my sentence calculator. Of course, that is through yesterday because these sentences commence today. There are a number of advisements I must go through. First of all, Mr. Brooks will be provided with a written explanation of determinate life sentence regarding the first-degree intentional homicide charges. Of course, he's not eligible for release to extended supervision. That form defines extended confinement for him, and there's other language on here that he can read at his convenience. He also will be provided with the Notice of Right to Seek Post-Conviction Relief form. The court will fill out the caption for him. He is instructed to review it and review the defendant's acknowledgement, make the appropriate selection, sign and date it, and return that to the court. I must advise you, sir, you have been convicted of a felony. That means you may not vote in any election until your civil rights are restored. You may not possess a firearm. You may not possess body armor. Both of those are punishable as felonies. You also have 20 days from today's date to appeal the decision of this court. Does the state believe I've overlooked anything here today?
No, thank you, Your Honor.
All right, those documents will be provided to Mr. Brooks. I will note for the record, at many times during my final sentencing remarks, he was holding up an objection sign. That objection is noted for the record. This now concludes this hearing and this case. We are now off the record.
Do you want to do the motion stay pending appeal, or we could do it another day?
I want to wait till